Hello and welcome to this episode of The Legal Loop, where today I'm joined by my colleague Kiera Greenslade and Kay Young, and we're going to be talking about some interesting legal issues and the ways around those legal issues for creative agencies, influencer marketing agencies, and also, just to throw it in there, some IT managed service providers. So if you're an IT managed service provider, or you're running a creative agency or an influencer marketing agency, this episode is for you. So Kiera and Kay, would you like to give us a background to who you are?
So I'm Kiera. I'm one of the client partners at Hybrid. I've been with Hybrid for just over 2 years actually. So within that, I handle a portfolio of clients, very mixed actually, but deal with creative agencies. And within that, there's a niche with influencer marketing, which I personally find very interesting. Just a bit of background about myself. I got into law when I was 18, started off as an accounts assistant, where I was just so desperate to get into law. I thought I'll take any job that I can within the field, and work my way up from there. So I've worked within criminal law, litigation, construction, and advocacy as well. So, and then I've joined Hybrid and really enjoyed the clients that I work with now. Wide variety of clients. So yeah.
Brilliant, thank you, Kiera. And Kay?
Hi, I'm Kay, and I am a senior commercial lawyer at Hybrid. So my journey into Hybrid is a little bit different. I started out as one of your associates. So I was a freelance lawyer. I worked with a couple of different places and on my own as well with a variety of clients. And then last year I decided to join Hybrid on a more full-time basis. And so here I am. My background in law is I did the very traditional thing of going to law school. I thought I was going to be a barrister because that's what everybody who goes to law school thinks. And within a term, I decided no. And so I pursued the solicitor route. I then went and did my LPC. Out of that, I did a bit of legal marketing and legal publishing, doing events where I got my interest in tech law because I was helping run events for, at the time, it was about e-commerce law and policy. From there, worked as a paralegal in a technology law department in a big city law firm. Absolutely loved it. Really enjoyed the area of law, and decided to make a leap into going in-house, which is where I actually did my training and qualified. So my background is actually in commercial and technology. I've got quite a lot of experience in fintech, working in insurance companies as well. And when I went freelance, I branched out a bit more and went more general commercial, but I've always had that real strong interest and passion for tech. So it's just such a fast-moving pace area of law, and it's always changing, and I'm a geek at heart.
That's not a bad thing at all, is it? Brilliant. Thank you, Kay. So I think what would be good to just start the conversation would be, tell me about the agencies and the IT managed service providers that you're working with, and of those clients that you're working with, how many don't have contracts where they're relying on goodwill and assumptions that everything's going to be okay?
So I will say that this actually applies to pretty much a broad spectrum of clients and not necessarily just MSPs, but the clients I've worked with and am working with, you get a real range. You've got some who are super organised and they've got lots of contracts, but then you get some who come to you and they're a little bit embarrassed, they're a little bit sheepish when they first approach you and say, I don't actually have a contract in place. And the response I usually give them is, great, join the club. There's a lot of people who start, because at the end of the day, you are a creative person or you're an IT company. You are a professional in what you know. That's what you care about. You want to get your business running. So you're going to focus on what you know. You're going to focus on your IT business. And then everything else is going to fall into place. You've got your clients. oh, right, don't have contracts in place, that's when you need to speak to the lawyers, and the lawyers will help you get those contracts in place. So it is actually more common than people think to not have a contract in place. It's not ideal, but it's very common.
So without a contract, for anyone that's watching or listening thinking, yeah, I probably fall into that bracket where, I've been doing business for X amount of time now and have survived so far without a contract. What's the option if they have an issue with their client where they don't have a contract in place? How can they go about solving that legal predicament in the absence of a contract?
Are we saying that they've already come across an issue?
Yeah, so it might be their client isn't paying, or it might be that client's expectations are very different from the supplier's expectations, and it's now looking at, well, what was originally agreed? What can be done in the absence of a contract, that signed bit of paper that would, in a dream world, set out all of these scenarios, but we know we haven't got that. So what are the options on the table?
Okay, without wanting to undervalue and go against everything I've just said about how important it is to have a contract, it's not the end of the world. So you are, by law, you can have implied contracts.
Cool.
So you can have a contract by just your actions. If you've been consistent in providing a service, and your client's been consistent in paying something to you, you can just about establish that, yeah, there's a relationship here, there's something going on. And what you could do is, I hope, have a really good audit trail of communications with your client. That you've got emails, you might be old school and have letters, but you've got something in writing, anything that just shows sort of communication between two parties that say, fine, I'll give you 5 hours of this and this will be the fee, and you get a reply from the client saying, great, when can you start? It's not ideal, not as good as a contract, but it's something.
Sure. So it sounds to me then that for those businesses that are trading quite gladly without a contract, that's fine if they are really organised with their admin.
Yeah.
If they're super organised with, as you've just described, Kay, with the admin, with the emails and how they've documented and recorded everything, they'll probably be okay. It's not ideal. Obviously, there's a lot of benefits having it all set out in writing with a proper contract. But otherwise, unless you're really good at admin, for those that are terrible at admin and haven't got a contract, is probably a bit of a sticky issue. But what's your thoughts, Kiera?
Well, I was going to say it's realistically about how organised you actually are. So if you're solely focused on running your business and providing that service, your admin might slip. So you're going to need to have, as Kay's already pointed out, strong documentation to be able to follow that and say, this is what we've provided. We've issued these invoices. The invoices have been consistently paid. So you're going to have all your ducks in a row, really, and make sure that everything's set up in a way that's consistent so you can refer back to it.
Yeah.
So I guess, as Kay said, the most ideal position is going to be if you have a contract in place.
Got it. Yeah, no, that makes sense. Thank you. So I think looking now at more agency-specific contracts, one of the key things that we see a lot of is scope creep. And in other words, the agency would have set out their expectations of what they believe they're going to be delivering, but that's not landed with the client because the client believes that actually they're entitled to receive something that's completely different to what was originally agreed. So I think it would be good to understand from both of your perspectives, how can agencies avoid getting themselves into that predicament in the first place? What can be done?
Okay, yeah, so scope creep. You've just said that the agency, has set out what they will provide, what services they'll provide.
Probably a big assumption, isn't it?
It is a big assumption. And also, often when you get someone who says, yeah, I've told the client what I'm going to supply, and you say, right, show me what you've written, and you kind of get 2 lines. I will provide you with marketing services. Okay, so you're going to provide me with marketing services. Right. In which case, here is a chicken suit. And I want someone in your agency to go stand outside the local supermarket wearing this chicken suit, holding up a placard with my business name on it. That's marketing.
Yeah.
And you didn't say in your scope that is outside the scope.
Yeah.
You haven't said what type of marketing services. Technically speaking, the client is right to ask for that. So it's the detail. It is absolutely devil in the detail. You have to put down exactly what you mean. So what type of marketing services? How many hours are you going to give? You can even go down to saying how many members of staff, the level of qualification. The more detail you have in there, the better. And again, one of the problems we have is people don't like paperwork. That's for the lawyers to do. People just don't like paperwork. Yeah. They want to have it in a really short contract. So the minute we say, can you make sure your scope is very solid and with lots of details, people kind of go, oh God, I don't want to have to do that. But if you think about what the risk is, isn't it worth it just to sit down for a few minutes and actually note it all down and have it in bullet points? The other important thing is to make sure that your scope is discussed with your client before you sign the contract. I often see contracts, hopefully nothing I've drafted, but I have seen it in contracts where people will say, provide the services to be agreed between the parties in writing after signing contract or after the effective date. That's a blank check. So what you want in the ideal world is when you're doing your contract negotiations, you're going to sit down with your client, you're going to offer them this piece of paper that says, this is the scope of services, this is everything we'll provide. And that's the chance for the client to then say, no, this isn't good enough, I want you to add this. And then you negotiate it. And then when you finally reach an agreement, it's signed, it's sealed, it's part of the contract. If the client, and also the client can't say, well, actually, I didn't agree, I didn't know the limits because they were involved in the negotiation. Then after that, if the client wants to change it, you'll have a change provision in your contract that says that variations and changes can't be made unless the parties agree it in writing. So again, it goes back to being organised and having things written down. You have the conversation with the client. The client wants more hours. They want the chicken suit to be written into the scope of services. You absurdly agree to it, and yeah, it's documented. So that's how to manage it. There's also the second piece of practical advice on how to manage scope creep, which is educating your staff.
Yeah, that's a really good point.
And I'm going to bring my husband into this conversation he doesn't know about this, so that I'm going to mention him, but he is not a lawyer. He's an IT stroke engineering professional in a team of techies. And he actually has a very good working knowledge of the contracts that his clients have entered into with his company. See, I praised him. That's good. And when I say he's got a good working knowledge of the contracts, I don't mean that he knows what their liability caps are or that he knows about the indemnities in there. He doesn't care or know anything about that, but he knows the bits that affect his job.
Yeah.
So he's really good at knowing what the scope of services for each client he's working is with. He knows what hours he's supposed to be working for them and how far he's supposed to take the project and what the client is supposed to send back to him, and that he can't proceed to stage B unless the client does stage 1A with him. And he knows all this fine detail. And the reason why he knows it is because the company he works for has a really good contract management team, and they've got a really good internal system where every single time a contract is signed, they do an internal, we've done something similar to crib sheets. So they do an internal document setting out the key parts of the contract in plain English for the staff. And so relevant members of the team know, okay, this is what I'm supposed to be doing and this is what I'm not supposed to be doing. And if the client wants me to do this, I have to escalate it to management. And then that will then trigger someone having a conversation with the client to say, actually, you've gone out of scope.
Sure.
We need to agree something new. So that's the second part, which is just about educating your own team.
Yeah. And Kiera, what's your view with the agencies that you're working with scope creep, that have encountered scope creep challenges? How are you going about helping them with that?
So I was going to jump off of what Kay said in terms of the crib sheet. So that's something that we have provided to our clients before, just a breakdown of what their contracts say. And it's a document that you can provide to your staff internally. And it will literally just break down clause by clause. This is something that you need to be aware of. This is a red, this is an amber, and this is a green. So if, for example, the contract gets sent out and it's negotiated, this is something that you need to be aware of. This is a hard no, you can't change anything here. And then just working through it. So in terms of like when you're filling out the statement of work for the services that you're going to provide, there's wording in that just to make sure there's not wording like including but not limited to. So which is where you can have your chicken suit example included within that. So as long as it's narrow enough to not have anything expanded, you just need to be careful of the wording there.
Sure.
And I would really recommend something like a crib sheet for having that internal training purposes for your team.
Sure. Okay. Well, what would be really helpful, could you just give me a summary of the key legal agreements that an agency should have as a minimum to put themselves in a good position legally when dealing with their clients?
I would most definitely say if you're an agency that work with subcontractors, you're going to need an agreement in place with your subcontractor, because I think we've definitely seen, I've personally seen an agency who engaged subcontractors with just an NDA. So where you then get into territories that you've got no protection for your IP if the subcontractor is creating something for a specific project. And I'm sure you've got some examples there where you've got a subcontractor who's creating content and they will automatically own that unless it's written into the contract to say I, the subcontractor, then assign that to the business. So that's something that's really important. You need that. Obviously, you've got your employment contracts if you've got employees within your business, services agreement, I think.
And the typical contract that the agency will have with its clients, I've heard a few phrases banded around, but for example, I've heard about a master services agreement and a statement of work that goes with that. It would just be good to understand, well, what do you mean by a master services agreement, or an MSA as it's abbreviated to, and an SOW? What does all of that mean, and why would it be useful for an agency to think about one of those?
So those are the client-facing contracts. And I'd say the MSA, the SOW, you could tell I like the tech world. I like acronyms. They're the bare minimum. An MSA is basically legal terms and conditions. That is it. Sure. That is all the bits that are there to protect you from a legal position, and in the ideal world, they're the bits that don't change. So it sets out who owns the intellectual property rights, what are your, if there is someone wanting to sue someone, how much for, is there a cap, all the legal promises that us, it should be the same for every single client. Obviously there will be some variation, but it's basically for an agency, it is your default position. This is our starting ground.
Sure.
The SOW, it's an order form, it's a commercial document, it's an operational document. There's so many different names for it, but it is the SOW, statement of work, is setting out what you are providing. So that's going to be where you get your scope of services. That's going to be where you set out how much your client is going to pay, and very importantly, when they're going to pay. sets out how long the contract's going to be. It sets out all the bits that are very specific to that particular client.
Sure. Okay, so it sounds to me that you have your master services agreement, which you're not really going to change much, if at all. But the statement of work that folds in with the master services agreement, that sounds to me like a flexible document that you can adjust on a client by client basis, which to me sounds quite attractive if I'm running an agency, because actually I won't want my account managers or senior leaders messing around with the core terms that I've just spent, some money with lawyers, getting perfected. But I wouldn't want to create a bottleneck where they're having to continuously ask for permission to change the terms in that master services agreement. So instead, they can go through the statement of work and adjust that to reflect whatever gig they're pitching for or scoping with the client. And as long as there is some kind of oversight there to make sure that they're not either over-promising or under-promising in that statement of work, and hopefully they're working to a sensible template that gives them guidance on what to say and what not to say, that sounds to me like a really good way for agencies to contract with their clients. What I'd be interested to hear is, have you seen agencies use statements of work that perhaps create some scope creep issues where they've had a go themselves? Kiera, your voice would be great to hear.
Definitely. I think this also ties in with AI.
Ah, yes.
So
I was coming on to that. Great point.
I've had a client in particular who, and I think it's normal in terms of wanting to win business and impress your customers, that they have been a little bit overzealous in terms of wanting to provide the service and impress someone. So in doing so, they've typed in these prompts into AI, and it's quite obvious that they've typed these prompts in, and in return, they've then been committed to these massive obligations that they don't realise will then be legally binding once they put that in the statement of work. So, for example, I had a client who committed themselves to such a high threshold, or was about to, and said that they would go above and beyond and make sure they fulfill all of these promises.
Which all sounds amazing, doesn't it?
Yeah.
From the person receiving the services, they're going to read that and think, oh wow, yeah, this agency's on it.
Yeah, and I think that was the intention behind it, because they obviously, they want to have a good relationship with their customer, but there's legal terms that an average person isn't going to understand. This is a high obligation, and once you sign that, you are binding yourself to go above and beyond, and that could mean anything. So yeah, I had a situation where that was written into a statement of work, and they ran it past me and said, is this something that you can just take a look over just to make sure that it's all okay? I was like, no, absolutely not.
It's not okay to go.
Yeah. That was one of those lucky instances where we were able to intercept and educate us as well, so that those things don't happen moving forward. Because obviously, I think AI is such a new tool, and it is useful, but you have to know what you're putting in to be able to then have the correct output.
Yeah.
So.
Yeah, really good point.
I mean, piggybacking off the point you've just made there, so even in a pre-AI world, I came across the same thing. I mean, if you think of AI, AI, it's learning, you're training it. Now, if you think of AI as the equivalent of a junior member of a team, so junior member of a marketing team, they're really desperate to impress, right? And that's great. They're really driven. AI is a bit similar to that, And I remember a similar scenario where I looked at a statement of work that had been put together by the marketing team, and as marketing material goes, it was brilliant. It was definitely going to get your clients in, because they referred to themselves as the industry leader, the best, and all this amazing wording. And I had the difficult job of sitting down with them. And at least you don't need to do this with AI. You don't have to worry about feelings. But I had a person I had to sit down with a red pen and say, you can't say this, you can't say that. because you can't declare yourself to be the industry leader or the best unless you actually have won an award that gives you that, because you don't want to be accused of misrepresentation. You can't say that you're going to do all these weird and wonderful things, because now in a contract you're actually saying you really will, and that's, at the cost of the company, because it's written down. They don't, the client, the law, they're not going to care about the fact that you can't afford to do all these weird and wonderful things. You said you're going to do it. It says that you can. So I guess, when we're going back to the original question about statement of work, have we seen cases where, clients and businesses have managed to trip themselves up over it? Yes, because of too much enthusiasm. And now I'm not saying don't be enthusiastic about your business. Absolutely. If you're not enthusiastic, and if you're not passionate about what you're doing, then why are you doing it? That's important for your business. But just remember that for a legal document, you have to have a sensible head on.
Yeah.
And also the other thing is, going back again to the MSA and SOW relationship, from my experience of being an in-house lawyer, people tend to think, right, MSA is the legal document, I'll go to the lawyers for that. The SOW is the commercial document, the lawyers shouldn't be touching it. And that's one train of thought. And the other one is, if you don't have an in-house legal team and you go to someone external, so, you come to hybrid legal, I don't want to pay a lawyer to look at my business document. I know my business, and this is not they've done the legal T's and C's. I'm going to save money. They've given me this template. They've taught me what to do with it. I'm just going to roll with it. Kind of not true. And, lawyers, a good lawyer will care about the business, and they will have an interest in it. So send your SOW, your statement of work, to that lawyer, because that lawyer can give you, like Kiera did for her client. She gave it the once over and spotted the legal mistakes, the over promising.
Yeah.
And they're not going to tell you that you can't do your business. They're just going to tell you you can't phrase it that way in a legal document.
I think the big value that I can take from there is it's the perspective that a lawyer can give a business on their contracts, because the perspective that the lawyer is giving that business is a perspective that's objective. They're zoomed out, they're looking at the business as a whole, whereas when you're actually in the business, much like us with our own firm here at Hybrid Legal, it's very easy to get tunnel vision. And we've certainly paid experts outside of Hybrid to give us a perspective on Hybrid to help us improve the way that we operate and the way that we approach things, which we definitely wouldn't have got to on our own kind of decisions. We may have done, but it may have been too late by that point. So I think it's the perspective that lawyers can give to your business, its processes, and most importantly, its contracts, that I think makes the investment in the professional fee worth every penny. But it's also an education piece, isn't it? Because when you start out in business, you don't know what you don't know, and apart from the thing that you set out to sell and to promote, obviously we would expect you to know everything there is about that thing, but quite a lot of people that set up their business aren't trained lawyers, so they're not necessarily going to think about the things that we would think about, so I think it's blending those two things together. But on the topic of AI, what are the telltale signs when you receive a contract? How do you know it's AI, or what do you look out for that will give you a red flag to suggest?
I think there's a few. I think my funniest one that I've seen has been within a policy that has a link and it essentially takes you to an AI website that they missed that. But I think the Americanized language and the way that it's written, it tends to lean more heavily towards that rather than UK.
Yeah. And on the Americanized contract, there's always a really good clue if it's American, which is Americans like to put, and I'm so sorry if anybody watching this is American, I don't mean to offend, but this is just a fact. American contracts, when they talk about the liabilities and the disclaimers, big capitalised
Capital
clause.
letters.
English law contracts don't do that. we don't do that. In fact, we use bullet points. We use, on our, we don't have the big
capital letters with
letters.
the box around it, drawing your attention to it.
Yeah.
So if you see a contract looking like that, it might not be AI, but there's a strong chance it is. If you know that your client doesn't have, if you know the business doesn't have an American presence,
Sure.
and then suddenly it produces this very American-looking contract, that's a good clue. And the other clue is, we like to build rapport with clients, who we work with. And I'm just thinking to one of your clients, who, you get to know people from your correspondence with them. You see the way they email, you see how they, their personality, how they talk. And then you see the contract or an email that's written by AI and it sounds nothing like them. Then that it's AI.
Yeah, that's interesting. So tell me about influencer contracts, Kiera. You obviously have developed a bit of a specialism for working with influencer agencies, and correct me if I'm wrong here, but you mainly look after the brands that are engaging with influencers. So just tell us about the typical legal challenges that you've helped those brands that are engaging with influencers solve.
So for example, within influencer agreements, there'll be terms that are kind of intended to trip up the influencer. So for example, you could have unlimited revisions, which is obviously going to be great for the brand, but not so great for the influencer, which essentially means that they'll have to repeat and redo the content until it's been approved by the brand. So, and in many instances, those revisions will be without any additional compensation. So as long as you've kind of established the fee, and if you don't approve that piece of content, then the influencer will have to redo it until you're happy with it. So there's that. There's also the approval period. So that's something that both influencer and brand should look out for. So within a campaign, for example, there'll be a set period where if the influencer is providing this content and you need to get it out for this campaign that you're doing, if you look at this piece of content and think, it doesn't exactly match the brief, then you need to go back to the influencer within a specific amount of time to allow them to be able to redo that. So that's something that both influencer and brand need to be aware of. There should be some sort of mechanism that will allow for approval, rejection of the content, and then within that a period that the brand will have to get back to the influencer to say, yeah, I like this piece, or no, I need you to redo some stuff here.
Sure. And what about IP, so intellectual property and ownership? Because I imagine that's a big thing between brands and influencers, because naturally the influencer is going to be either working with some IP or creating some IP on behalf of the brand that it's promoting. So just talk us through some of the IP ownership challenges that you've seen.
Yeah, so this is where having a contract in place is the most important thing, because once a piece of content is created, it is typically by default owned by the content creator, unless there's something written in the contract to the contrary. Within my experience, I've most commonly seen the influencer licensing that out to the brand rather than an outright assignment, which is just the more common thing to do these days. And then obviously with the assignment, it comes at a much higher price tag than the license, because you'll be owning that and you can do with it as you please. So a lot of brands like to have an unlimited license, but you'd see the influencer push back and want to have that limited to say 180 days. It will be live on the social channels before it has to be removed.
Sure.
So Yeah.
And how about timing with working with influencers? Because I imagine that, a lot of these campaigns are very time sensitive.
Yeah.
So tell us more about that and how that lines up with being organised with contracts.
Yeah, so with campaigns, it's very quick turnaround. So you're obviously having to engage and activate your influencer, issue the contract, because you don't want to be engaging an influencer without that written contract there, especially if you're an agency that would engage the influencer and then also work for the brand separately. So I've had an example in going back to the IP where my client had a contract in place with their influencer, and within that the license was granted for 180 days, and then after that the content had to be removed by the brand, whereas the contract that was provided by the brand to our client was an assignment. The agency provided an assignment that they didn't actually have from the influencer. So that could have got into big dispute territory where they've promised something that they don't actually hold. So luckily within that scenario, it was a template contract that the brand had used. So it was something it was just settled with a conversation. So they didn't actually want it to be an assignment. It was in line with what was in the contract with our client and the influencer, luckily.
Yeah.
Because in those instances, that would have incurred a much higher fee if the brand was expecting an assignment of the content that the influencer was providing.
Sure.
And they only received a license.
So the summary of the key lessons there, then, how would you summarise that?
Make sure that you have somebody check off your contract before you're signing it, even if it's just a quick glance over. It's always best to have that reassurance and peace of mind, because the risk in the long run could be far greater than just having a quick 1 hour review over a contract.
So, Kate, tell us more about the key contracts that an IT managed service provider should really be thinking about having in place.
Okay, so again, it's kind of going back to the MSA, SOW territory. You get some MSPs who put together, instead of an MSA, they'll do a SaaS agreement, so a software as a service agreement. But without going into too much detail now, again, it kind of just cuts down to, it's the key legals. It talks about who owns what you're getting for the service. And SOWs, again, it's the operational commercial document. Now, more specific to MSPs in the IT world is SLAs, so service level agreements. Again, that's a funny one where I have dealt with companies that basically said, lawyers, go away, hands off. And yeah, I respect that. I can't tell an IT company, what level of service they should be giving, but I can advise on what's sensible and what to expect the client to push for. You can agree to response times, so keep your client happy. If they've got a problem, then half the time people just want to be heard, so give them a good fast response time. Don't agree upfront to fixing the problem within a certain time, because unless you can predict every single scenario, you can't guarantee, and then you put yourself at risk. Yeah. Service credits is another one which you hear a lot about. The typical client will ask for service credits because it's basically, I didn't get my service for 24 hours. Why did I pay you a day? I want my money back. It's essentially asking for a refund, but not in a refund. Again, as a starter, I tend to say avoid them. It's giving away discounts. It's giving away refunds. It's not good for business in the long run, especially if you've got a very large client base. So yes, the service level agreements is one of them. Data protection agreements, IT security documents. Again, there's always a lot of debate about whose territory are these documents. Data protection, your client, the business the MSP, I should say, may well have a compliance officer. They should absolutely get involved and looking at our data protection schedule and looking at what technical organizational measures they have in place to protect the huge amount of personal data they could potentially be dealing with. But again, work with the lawyers. The lawyers are going to know about the updates in law. I'm not saying the compliance team won't. I should really hope a good compliance team does know, but work with the lawyers to make sure that the language in a data protection schedule or a privacy policy flows with the language in your main contract. So going back to what we were talking about with AI, you don't want to have a contract which has been worded in a particular style to then have a privacy policy or a data protection policy that tags onto it that uses completely different language and completely different style. It just doesn't flow. And it's the same with IT security as well. Again, okay, we may not be the experts in the absolute tiny detail in what your IT security protocols are, but we can review the schedule, make sure it works with the contract.
Absolutely. Yeah, I think you've made some excellent points there. And one of the key things that stood out for me was around the service level agreement and having a quick response, but not promising a quick solution, but that really important point of the customer feeling heard and feeling that somebody is on the case, it's in a safe pair of hands and it will be addressed, instead of the radio silence and the echo chamber that the customer feels that they're shouting into, which can then just create further issues that could be easily nipped in the bud just with that regular communication piece. So that's really good to know. The other thing that I'm thinking about from what I've seen with managed service providers is a lot of them will be reselling the software products of the vendors, but they may not think about the contractual consequences there, because they'll have a contract in place with the vendor and then they won't be thinking about the contract that's in place with their customer, who is ultimately benefiting from the service that they're reselling, or rather the software product that they're reselling. I can think of some pretty big brand names that have made some recent changes there. So just tell me more about that concept.
Yeah, so it's a bit similar to what Kiera was saying about the influencer market, where, your contracts are very rarely standalone documents. They are in a long chain. If you think about it, contracts, paper, lots of little paper chains. We could actually just draw a big paper chain of contracts. And you've got you've got the provider of the software down here. Then you've got the middle chain. You've got the software here. You've got a chain here. This is your contract. This is the MSP, this is the software provider. You've got your contract here. MSP then has another contract over here with the client. You need to be able to flow through that chain, the same risks and the same rights, to protect the person in the middle, who's the MSP. And one of the common trip-ups, and again, this is overlapping with the influencer world, is you've got this software, but it says for internal business use only. So you can't use your client can't use it, technically speaking, because you haven't got the license rights. And it's, again, it comes down to this whole thing about assignment versus license. And I think there's a lot of people out there, and hands up, before I became a lawyer, I didn't know the difference. Assignment, license. It's essentially, do you own it or do you rent it? You can't, just to use, rental as an example. I know we're kind of going off on a tangent here, but if you think about assignment is ownership, assignment is the landlord of a property, and you think of license is the same as a lease, it's a rent. You can't rent a property and then, start using it to rent out. I'm going to rent out this. I'm going to sublet this room, sublet that room, and sublet this to multiple people and make money off it. Unless your contract allows you to do that, you can't do that. You're not the owner. You're not the landlord. And it's the same with license and software. You've got this software that you're using. That's great. but you've got to make sure that you've got the rights to use it for what you want to do. And if what you want to do is to be able to roll it out as a service for your end clients, then you need to check your original license allows you to do that.
Yeah, really good point. Thank you, Kay. So my next question for both of you is around businesses that are watching this, that are thinking of working with larger brands or are already working with larger brands. What should they be thinking about from a contractual perspective? You know, what are the things to look out for and the things to expect?
Large brands, it's the David and Goliath scenario. You'll often get large companies, and I will admit that I've done this in the past because I have worked with some rather large companies in the past. I've worked for little ones and large ones. Large ones know that they have power.
Yeah.
And they will have a team of lawyers. They'll have a procurement team. They will have, they'll have teams within teams. And they've got standard documents that they have invested a lot of money in and they're very proud of, and they will insist that the little provider will sign up to their documents. So we call it the battle of the forms. That's one of the big, probably the main starting issue. And often you'll get this document, it will be very long, and it'll probably also be locked so that the only thing you can change is your company name and probably the pricing.
Yeah.
But everything else, all the legal T's and C's, it's all being set by your big customer. Now, it's really tempting if you are a smaller company to just sign on the dotted line. You think that you haven't got the power to negotiate, but also just see it as, we'll take this one because it's a really big win. We can advertise it. We can say that we've worked with this really big client and it's going to bring in lots of business for us. Chances are that document probably has a no publicity clause written in it, so that you can't do that. It's written in there that the contract and the engagement itself is confidential. You're going to breach confidentiality if you go out there and start telling people about it. So there's a lot of detail in it. And so then that kind of brings us to the next topic of when a smaller company, an agency might say, well, okay, but then how does that mean I'm going to end up losing the business? Because this is a really good, lucrative deal. I don't want to lose it. You don't ask, you don't get. So ask to edit it. Ask to amend the contract. It's amazing how people will often, if you can present your case and say, look, pages 10 to 18 don't even apply to my business, people will tend to listen, because at least it will show that you've looked at their contract. I get more worried when somebody just signs a contract without making any type of amendment, because it means they haven't read it, which is worrying.
Yeah.
Well, you see it on DocuSign or the electronic signing software providers, where you'll issue the contract and within 5 minutes it's come back signed, and you think to yourself, my goodness me, how have you managed to read all of that contract?
Yeah.
That quickly? Of course they haven't. They've just gone,
or
done.
They asked their AI to review it and AI just said it's great.
Yeah.
That's the other risk.
But Kiera, you were going to say.
I actually find that, like you said, if you don't ask, you don't get. But they're more reasonable to negotiation than you might think. So even if it's just a case of having your contract reviewed so that you as your business owner know these are the risks that I am signing up to if I do sign on the dotted line and don't make any changes, so you're aware of what you're actually getting into. I think that's the biggest thing. But also, as we've said, some companies are actually a lot more reasonable than you expect them to be. So they are open to making changes. But
yeah. I mean, one way to think about it as well is these larger companies have an in-house legal team, these people on a salary. And in addition to that, they're probably going to have external counsel advising as well. Common misconception about lawyers is that we are there to fix problems when it goes wrong. Not true. We also are there to prevent problems. So we want people to talk to us, when they're excited and they've got a new opportunity. That's when we want. I'm not a litigator, so I like the before bit. And if you think about it logically, you've got a big company and they've got a team of in-house lawyers there. Now, if that in-house legal team, their only job was to draft the perfect contract that will go out and be signed with no objection, they've got a very, very short shelf life, that legal team, because once that perfect template's been done, then surely they're made redundant. So they've got an in-house legal team because they're expecting people to say, about this contract, this clause doesn't apply, can we take it out? Or this limitation of liability, that will bankrupt us. That's more than what we can pay out. You know, we're not saying we want to breach the contract, but this is unrealistic for the service that we're providing you. And the other thing is, you know, it's often you'll find that it's a one-size-fits-all contract from the larger companies. Doesn't work because every business is different. If every business was exactly the same, they wouldn't need to go to various different agencies and businesses to provide the service. They'll just go to one place that will provide everything.
Yeah,
I think
that's a really good
as
point.
well, it's always important to know if you've got to the point where you've actually received a contract from this big client, you're halfway there. So they, even though you might have your David and Goliath situation, they're interested in you and they do need you. And it might not be as difficult as you think to be able to negotiate that. And that's what I like about hybrid, where we get to know our clients, so we're more familiar with their appetite for risk. So if we're going into a contract negotiation, and again with those big clients, you might think, oh my gosh, we've got to turn it around so quickly. By us getting to know your business and we know, they're not going to accept that, it allows us to turn that around quicker for our clients as well.
Yeah, absolutely. Well, do you know what? It reminds me of a client that we look after that's in the maritime industry, and they deal with some very large tech brands, of all people actually, maritime and tech having a bit of a crossover. And I remember seeing some of the names that they were signing contracts with, and I think their original mindset was, can you just tell us what's in the contract and we'll just sign it with our eyes wide open? But to your point, Kiera, getting to know the client, understanding the business, understanding, you know, how good they are at providing that service and what they're worth, and having that strength to negotiate with the so-called Goliath, you know, it actually worked for them, where the big tech brand started to concede on some really important points to our client that we were looking after and still represent to this day. And I think that just completely amazed the client, because they thought, oh my God, how is this particular household name, you know, agreeing to these changes to this particular document? And to your really good point, Kay, they have in-house teams for a reason. They are there to, you know, make adjustments. Otherwise, if there was absolutely no adjustments whatsoever, what would be the point of having an in-house legal team? It's a really good challenge there, you know. So I think it's a bit of a mindset shift and a confidence piece for sure.
Yeah, definitely.
So yeah, really good points. So Kiera and Kay, what is one key thing that our audience, you know, should really consider when it comes to contracts with their business?
Well, I would definitely say if you can afford it, it is worth getting it reviewed by a lawyer before signing.
I'm very much in agreement with that. And the other thing is, you know, I realise some people are going to say, well, lawyers are expensive, or I can't afford it. Then, you know, at least put aside a bit of time, put about, you know, just a little bit of time. Listen to things like the legal loop and understand what things to look out for, and go through the contract yourself and just understand it. If there's anything you don't understand, ask a lawyer, ask the other side, what does this mean?
Yeah, really good point. Even asking the other side to clarify, you know, what's meant by that, I think is absolutely better than nothing.
Yeah.
You know, so yeah, really good pieces of advice there. Thank you very much, Kiera and Kay, for the conversation today. Thank you for listening to this episode of the Hybrid Legal Loop. If you have any questions, please don't hesitate to get in touch. Don't forget to subscribe to our YouTube channel to get notifications on upcoming episodes, and also feel free to subscribe to our regular email newsletter, which will give you legal tips and insights. There's no sales pitches, it's just real insights from our legal team on what you can be doing with your business from a legal perspective. Thank you very much for listening.